The second speaker will be Mark Kirsten, who is on the program. It's my version still London School of Economics, but as I understand now at the University of Toronto. He also will address a number of rather fundamental questions under the title Justice in Conflict-Affected Situations, Changing and Charging the Narrative. Mark, please.
Thank you very much. Thanks to everybody for being here. I'm very excited and for the next couple of days and to learn from you. Thank you to the organizers in particular and to Justice Wikipedia. Thank you very much. I'd like to highlight, and I don't know if this is going to be a popular statement or not, but I'm not a lawyer. I come from a background of conflict resolution and conflict and peace studies. And what I'd like to do with my remarks is three things. First, I want to talk a little bit about how interventions by the International Criminal Court affect conflict narratives, and I'll explain what that means in a second. Second, I'd like to discuss how this, in turn, may affect both conflict resolution and transitional justice processes. And then thirdly, I'd like to offer some brief remarks on how all of this might relate to a potential ICC investigation in Ukraine. So first of all, conflict narratives. So in my research, I actually argue that the most significant and the primary effect of the International Criminal Court when it intervenes in ongoing and active conflicts is on conflict narratives. And what I mean by conflict narratives is really the dominant or primary understanding of what a conflict is actually about. So what caused the conflict and what allows or what drives the conflict to persist. Generally speaking, in conflict resolution and conflict and peace studies, we tend to focus on a debate called the greed versus grievance debate. So either a conflict is caused by greedy actors, rational, self-interested actors who benefit somehow economically from a conflict, or it's grievance-based, so it's more social-based, it's an identity-based conflict, or an ethnic-based conflict, or a religious-based conflict. I think now there's some consensus that it's actually neither one nor the other. There's interaction between greed and grievance that helps explain why conflicts begin and why they persist. But what happens when the ICC intervenes? Well, I would argue three things. First of all, the dominant narrative tends to shift a little bit towards one that pits good versus evil. It's quite simple, but essentially the ICC's targets get castigated as evil perpetrators, and those targets or those belligerents that avoid scrutiny from the ICC are seen as de facto good. This is particularly true because if we look at the ICC's record, it tends to only target one side of a conflict and very rarely both. The second effect is individualization of the conflict narrative. So these evil perpetrators that the ICC targets are not just seen as criminals, they're actually seen as the very cause of the conflict itself. This feeds into a mantra that exists within the Office of the Prosecutor of the ICC, as well as in global justice circles, that in fact prosecution is in itself a form of conflict resolution. Because if the cause of the conflict is this evil perpetrator has been prosecuted by the ICC, if you remove them and put them in a courtroom, you will somehow have peace. And thirdly, the causes, whether they're greed or grievance-based, are essentially made irrelevant in dominant narratives when the ICC tends to intervene. Conflicts are more or less seen as, the causes and dynamics of a conflict focus more in these types of narratives on the manner in which the conflict is actually perpetrated. So the fact that atrocities are perpetrated becomes more important than why those atrocities have been committed in the first place. And as I mentioned before, the ICC has this propensity to intervene in ongoing and active conflicts, which then exacerbates its effects on conflict narratives. So secondly, conflict resolution and transitional justice and how conflict narratives may fit in and how the ICC may fit in. I think it's first really important to highlight that the truth is we still don't know what the ICC's actual effects are on conflict resolution or on transitional justice processes. The record, in particular the empirical record, is simply not strong enough. However, I do think it's clear that conflict narratives and the way that the ICC feeds into them affect belligerents and both their attitudes towards entering a potential peace process as well as their attitudes to participating in any type of transitional justice program or mechanism. Here, in a sense, I take transitional justice mechanisms to be defined sort of as an attempt to resolve or transform the conflict narrative itself, not away from conflict, but away from expressing that conflict through violent means. So of course, when the ICC intervenes, the big question is, how will the ICC's targets respond to being targeted, and then how will this affect them in terms of engaging in a peace process, in conflict resolution, and in transitional justice processes? I think clearly sometimes, and this is the dominant view, those targets will respond through violence. So there'll be an arrest warrant issued for them and they respond to violence. You see this all the time in newspapers and media reports that if we issue an arrest warrant for Assad or for Gaddafi, they'll dig their heels in and respond violently. Here, however, this is possible, but here, however, I would just highlight that we do not know why an individual or a belligerent would respond violently. So for example, is it because they're humiliated by being indicted, or is it an attempt to show that they still maintain power? It's still not clear why they would. And secondly, I think we have to be very, very careful about making strong causal claims. In the international criminal justice world, we tend to say that, you know, if an arrest warrant is issued for this person, they'll respond like this, and just ignore all of the other conflict dynamics which may feed into decision-making of particular types of perpetrators. However, I do think it's also true that targets of ICC interventions don't always respond violently. In fact, some, like the Lord's Resistance Army in northern Uganda, responded to being targeted by the ICC by exploring and in fact engaging, at least to some degree, in peace negotiations with their adversaries, the government of Uganda, as a means, I would argue, to challenge that conflict narrative that they thought was biased and unfair and which the ICC fed into. And then I also think it's important to highlight here that actually, and I find this a lot in my research on Libya and Uganda, that it's the non-targets of ICC interventions that tend to respond violently to the ICC's intervention in the first place. This might sound counterintuitive, but if you imagine that the ICC tends to intervene against only one side of a conflict, the good side, so the side that isn't targeted, tends to interpret this as a kind of moral and political stamp of approval, not only from the court, but from the international community more broadly. And that stamp of approval essentially says that your conduct in this war, or your conduct in this conflict, is correct. And what we see in many instances, or at least a few instances, is that that leads that non-targeted party to commit to a military solution and to violence. That's one thing, and two, they also can use, and we see this as well, they use the rhetoric of international criminal justice and conflict narratives to reject peace negotiations or engaging in transitional justice processes by saying we can't do that because these adversaries are now evil, they're now criminal, we don't engage with them. Thirdly, some thoughts on the case of Ukraine and the transitional justice and the possible ICC investigation here. I do want to highlight that these remarks are coming obviously from the outside, from an external kind of perspective. I follow news reports and various NGO reports, but I do want to highlight that I'm not an expert on the case by any stretch of the imagination. But how does all this relate to the case of Ukraine? So first of all, I think it's really important to stress that the ICC will not and cannot help address the root causes of the conflict in Ukraine. They are far, far beyond the temporal jurisdiction of the ICC. The ICC only has jurisdiction since the 21st of November of 2013. And in its last preliminary examination report, the Office of the Prosecutor, under the heading of background and context of the conflict in Ukraine, cited former President Yanukovych's decision not to sign the EU association agreement and the events in Maidan Square. That's as far as it'll go for background and context. It will not even attempt to seek to address or to cover any of the factors or dynamics that may have led to those events. And I think it's clear to even the most casual observer of the conflict here that the causes of the conflict go much further back, and indeed go further back. I think we saw this last night with Philip Sands' documentary as well. Go even further back than the greatest extent of the ICC's temporal jurisdiction, which would be 2002. Indeed, there seems to be a growing consensus, and I think we heard this a little bit today and yesterday, that the conflict stems from divisions and tensions over the politics of memory, and specifically, and this was an interesting report from the International Center for Transitional Justice, a battle between a neo-Soviet historical narrative and a nationalist one that has persisted in some form for decades. So if the ICC ends up pursuing asymmetrical justice, which again I think is very possible, only targeting one side and not both, I think the ICC could very easily end up exacerbating rather than helping to alleviate this narrative division. So what this means, I think, one, caution will have to be paid to how the ICC fits into these conflict narratives, and secondly, transitional justice processes will have to be designed clearly to deal with the tug-of-war battle over memory politics. Secondly, individualization of responsibility. Again, I think Philippe Sands spoke a little bit about this. I think it's understandable to want to pit responsibility of a conflict on singular individuals, but it is problematic when it comes to conflict resolution. I think there's a tension here between ascribing criminal responsibility for particular acts or atrocities and ascribing responsibility for a conflict on particular individuals. Criminality might be ascribed to singular individuals, but conflict resolution, I think, requires us to look at more systemic causes, social, political, and economic factors, and how these fit into memory politics. And then finally, my third point here is that if all sides committed atrocities, then targeting all sides by the ICC, whether or not this happens or not, but targeting all sides will be beneficial for transitional justice processes, I believe, as well as peace and conflict resolution. It's not clear that this will be the case. Sarah alluded to this, and the government, when it accepted, the government of Ukraine, when it accepted a potential ICC intervention, actually said or described the law as, quote, on the recognition of the jurisdiction of the ICC by Ukraine over crimes against humanity and war crimes committed by senior officials of the Russian Federation and leaders of two terrorist organizations, DNR and LNR, which led to extremely grave consequences and mass murder of Ukrainian officials. So we see there an attempt to really, this concept of lawfare to point the ICC in a direction against adversaries, which most governments tend to want to do, of course, for quite understandable reasons. But if the ICC interventions ends up being one-sided, it will feed directly into current problems, I think, and challenges with memory politics. If the ICC only targets Ukrainian and Ukrainian-affiliated actors, it will only embolden Russian forces and their allies to continue military operations and confirm their neo-Soviet version of memory politics. But similarly, if the ICC only targets Russians or Russian-affiliated belligerents, then it will give Ukrainian forces and allies the impetus to attempt to win through violent means and reaffirm their particular version of the conflict narrative. I do believe that neither of these two scenarios would be useful for conflict resolution or indeed for transitional justice. So whatever happens with the ICC, whether it intervenes and opens an investigation, an official investigation or not, I think it's critical to be to think through very carefully to ensure that the court and any activities that it does do not entrench narratives and divisive memory politics, and to think through how it might be complementary to some other processes, in particular processes relating to conflict resolution and transitional justice. Thank you very much.
Thank you, Mark. Third and final speaker is Marko Milanovic, Vice President of the European Society of International Law and also at the University of Nottingham. Marko will, in a way, proceed on the previous presentation and ask the question, if an international tribunal is in place and actually renders a judgment, how will the population perceive the outcome of any such verdict? So the title, when are international criminal courts likely to be believed by local audiences? Mark, please.
Thank you, Andre, and thank you everyone for coming, and thank you to the organizers for inviting me. I mean, you outlined my topic very well, and as you say, it relates, it comes along nicely from Marx. My topic really comes from essentially my background, which is that, that I'm from the former Yugoslavia, from Serbia, and I was interested for a long time in how do we know what the impact of the ICTY, the Yugoslavia Tribunal, has been on the attitudes of the former Yugoslavia. And I wrote a paper about this, which was based on this wealth of properly done surveys of public opinion in all countries of the former Yugoslavia, so in Serbia, in Croatia, in Bosnia, and in Kosovo, over an extended period of time. And these surveys of public opinion confirmed my general impression, but in a very sort of properly rigorous scientific way. And they showed that essentially the communities in the former Yugoslavia do not believe the ICTY if it is not convenient for them to believe the ICTY. So they only believe in the findings, the factual findings in the court's judgments, if these findings align with their predispositions, with their prejudices, with the official standard narratives about the conflict, about the particular crimes that they've already absorbed. So for example, in Serbia, the majority population is ethnic Serb, and only 10% of that population accepts the finding of the ICTY that the worst crime of the Bosnian War, the Srebrenica genocide, happened in the way that the ICTY said that it happened, that in July 1995, 8,000 Bosnian Muslim men and boys were killed in a couple of days. Only 10% of them accept the ICTY's version of the truth, right? The rest either accept something less or deny more broadly, but 90% engage in some form of denialism. If you look at Bosnia, for example, 90% of Bosnian Muslims and Croats accept that there was a 3-year-long siege of Sarajevo in which thousands of civilians were killed. But only 24% of Bosnian Serbs do. And this is something you could watch on TV, right? But you still have this enormous disparity. And the surveys are the same when it comes to crimes committed by Kosovo Albanians against Serbs. Serbs believe those crimes, Kosovo Albanians don't. If it's about crimes committed by Serbs against Albanians, Serbs don't believe in those crimes, Kosovo Albanians do. So when you aggregate the whole thing together, you will see that those populations, those peoples who were targeted by the ICTY, in the sense that many persons who were from that ethnic background were either indicted or convicted, those communities, the Serbs and the Croats, they really hate the ICTY, and they've always hated the ICTY, and they continue hating the ICTY. Whereas those populations where their victimhood narrative was essentially confirmed by the ICTY, and that's the Bosnian Muslims and the Kosovo Albanians, they conditionally, more or less, trust the ICTY. So that's essentially what we actually know from that example. The ICTY, if you think the role of an international tribunal is to establish facts that somehow members of these affected societies will believe in and arrive at a joint truth, and that on the basis of this joint truth they will reconcile and do all that nice fluffy stuff, right? If that's the mission you set before the ICTY failed. Perhaps that's not the mission you should set to the ICTY. The mission should be something else. It should punish people who really committed crimes, and that's it. Or you might think of something else, satisfying the victims, whatever, right? But if your idea is a tribunal such as this one is to establish the facts, the truth, the problem is that, at least in this case, all of these communities have parallel truths. It's like Donald Trump with alternative facts, fake news. Fake news is all you've got there. Alternative truth is all you've got there, right? There is no single reality. There are 4 or 5 parallel realities. And if I'm in Ukraine, I'm not talking science fiction to you. You are living this. There's an official Ukrainian reality of the conflict in Ukraine, and then there's the official Russian reality of the conflict in Ukraine. This is, I mean, the way this works is, I like to call this the Wikipedia approach to reality. So there is, if you look at Wikipedia, there's a Serb version of Wikipedia, there's a Croat version of Wikipedia, there's a Serbo-Croatian version of Wikipedia, there's a Bosnian version of Wikipedia. These are all the same language, by the way. This is actually one language. But you have 4 different Wikipedias because they want to have 4 different truths. And I am sure if you looked at articles in the Russian version of Wikipedia on Crimea and the Ukrainian version, it would be 2 different truths. There are dissidents, right? These are not monolithic societies. So there will be differences in views, okay? But there is nonetheless a standard reality in all of them, which the ICTY, when it comes to Yugoslavia, was not capable of changing in any sense. Now, why is that? So why is a tribunal like this one, at least in that one example, proved to be so impotent? What's the explanation for failing to acknowledge what the tribunal said? My theory is that the root explanation for that kind of question can only be found in human psychology. There is no way to talk about this question in legal terms. It's a psychological question. How is it possible that people disbelieve in the existence of atrocities of this type, even when they're established by an international tribunal? And so basically, I tried to explain the ICTY's failure by postulating a number of factors that we can call internal or external or subjective and objective that essentially influence individuals in how they process, how they cognize information that comes to them about specific atrocities. So let me tell you about some of them, and I think you will see how these factors, I think, are of a generalized importance. First, there are these so-called objective limitations. The first problem is distance. Think about how you know things. How do you know about whether a particular village in eastern Ukraine was targeted by whatever group? And you're sitting in Kyiv. You have no way of knowing directly what happened there. You're not observing it with your own eyes. Yeah? You're relying on somebody else for the information you get. That somebody else, and I'll call this mediators of information, can be various people: government, non-governmental organizations, the media, education. Yeah? So, but the basic point is that you are not directly the witness of most of these events. And if you look at most mass atrocities that happen on the planet, right, an individual is almost always distant, even if they're the victim, right? Even if you're in Auschwitz, you're a Jewish inmate of Auschwitz, there is no way for you to know that 1 million people have been killed in Auschwitz, right? The scale of the event is beyond the comprehension of any individual. And there is no way, again, even if you're a Holocaust survivor, that you know directly that 6 million people have been killed in the Holocaust, yeah? Or however many million, outside the Holocaust in World War II. So this is always an information you have to rely on somebody else to get. Yeah? That's problem number 1. Problem number 2 is that most ordinary people don't have the time or the resources to think about these issues in any kind of coherent way. If you are working for a 200 euro salary as a cleaner in this hotel, yeah, how much time do you have to think about the Ukraine conflict, what is actually going on in Crimea, what is actually going on in eastern Ukraine? Yeah, are you going through the evidence yourself? You're not. You're absorbing a narrative that comes to you from those mediators of information that I've already mentioned. So you don't have the time to actually think about this. Third, all of this is subject to political manipulation. Politicians and elites that control the media, that control the education system, they benefit from purveying a particular narrative. If you're Vladimir Putin, you benefit from selling a particular narrative about the Ukrainian conflict to your population. If you're the president of Ukraine, you also benefit from selling your own particular narrative. If you're the president or elites more broadly of Serbia, Croatia, whatever, nationalism was how these conflicts got started and how these conflicts still continue to live on, even though it's been 20 years, right? So that, I think, is an inescapable, and as we'll see later, crucial consideration in how information actually gets processed. So these are the external factors. How about the internal ones? Psychologists have done an enormous amount of research, incredibly verified, experimentally, and so on, that shows just how bounded human rationality is. We are not objective information processors. We are all subject to an enormous amount of biases that warp how we think about anything. So the classical cognitive bias of that type is confirmation bias. Once you start believing in something, you learned about it in school, you learned about it from TV, you will be predisposed to assimilate any evidence about that event that comes later in a way that confirms your pre-existing beliefs. Another form of bounded rationality is the link between emotion and cognition. So neuroscientists have demonstrated, for example, that the same parts of the brain that deal with rational thinking are the parts of the brain that emote, that do emotion. There is no, if you look at yourself, if you reflect on yourself, there is no rational part of you and an emotional part of you. You are one person. Yeah? So people who think about events in the former Yugoslavia, or who think about events in Ukraine, they don't simply think about them, they feel them, right? You feel a truth about the Ukrainian conflict. You feel there's a justness to a particular side and an unjustness to a particular side. And there is no way for you to escape that, yeah? Even, no matter how intelligent you are, no matter how objective you try to be, emotion is always controlling how you process information. Then there are various other sorts of biases. For example, on the basis of group identity, in-group, out-group bias. Do you identify with a particular group? Do you not identify with a particular group? The problem is that many of these conflicts in which atrocities happen are really based on group identity and so on. So it is the interplay of these factors that, in my view, explains how millions of people who are otherwise normal, fine, moral people who you would like to have dinner with, yeah, are capable of denying crimes that actually did happen. Yeah? They think about them in a way that maintains their internal illusion of objectivity. They think you're wrong, that the ICTY is wrong, that the ICC is wrong, or whoever, right? And that they're right. And they feel that they're right. So, if that explanation of how the ICTY failed is correct, and I think it is, the question comes, how do we then know, can we predict how other societies that are dealt with by other tribunals, how they will react to the findings of these tribunals? And all of the factors that I mentioned before, I think are present more or less everywhere. So for example, when we talk about distance, sometimes there will be a significant amount of distance, sometimes the distance will be lesser, right? If you're in Rwanda, you could see people being killed on the street in a way that you could not necessarily see in the former Yugoslavia, right? But distance will always reassert itself, intergenerationally at least. Think about the children of Rwanda today. They did not experience the genocide. So they're learning about it from their parents, their grandparents, from schools, yeah? So that reliance on others for information will always be there, as will all of the other factors. So I think the one thing that varies the most, if you look at these different societies and different tribunals, is the reactions of elites and how much they're willing to invest in politically manipulating the information that comes through about specific events. Will they, in short, oppose the work of the tribunal, or will they at least be neutral towards it or support it in some very vague way? If you have a society which continues to be polarized along group basis, where the elites perceive the continued work of a particular tribunal as a threat to them, a threat to their position, to their power in the affected society, these elites will have an interest in creating a polarizing attitude of the population against that tribunal, and in continuing to manipulate the narratives about specific crimes. And I think that this predictive factor elite reaction is ex hypothesis, it is predictive of failure. And I think that hypothesis is actually validated by the experience of all individual tribunals we've had the experience so far. So I do not have the time to talk about this in detail, but in the paper I deal with Germany, with Japan, with Rwanda, with Sierra Leone, and with Cambodia. And in these 5 societies, you have 5 different reactions to these tribunals. And I think they are all very much aligned with the hypothesis that I've outlined. In particular, you can see that in Germany, it was not the Nuremberg Tribunal that provoked the catharsis in German society that means that the Germans today believe in the Holocaust. You can in fact see how once the German elites reasserted themselves when the big part of the occupation ended, they immediately reshaped German public opinion in a way that the tribunal became an instrument of victor's justice, an unfair trial, and was relegated to oblivion. You have a whole generation of Germans who grew up and they did not talk about the war at all. They certainly did not talk about the crimes at all. And what provoked catharsis came much, much later. So for example, a lot of historians like Tony Judt will tell you that the cathartic event in German society came in the 1970s, and that one of these big things was a Hollywood TV miniseries on the Holocaust starring a young Meryl Streep. You know, Meryl Streep did more for German acceptance of the Holocaust than the Nuremberg Tribunal did. You had telethons, you had historians answering phone calls from people. How is it possible we never knew about this? How is it possible that nobody talked to us about this? Yeah? The tribunal itself was an irrelevancy. In Japan, you have this remarkable degree of elite continuity. The occupying forces in Japan immediately made the decision that the emperor and the imperial family will not be touched with prosecution. That in fact, the biggest part of the civil service in Japan will never be touched by prosecution, or even by milder forms of purges. Yeah? It was really only the military elite that was subject to trial at Tokyo. Unlike Germany, Japan actually maintained its government even during the occupation. The same people who ran Japan before the war continued to run Japan after the war. Today, of the past 10 prime ministers of Japan, 7 have been the sons or grandsons of post-war prime ministers of Japan. One party, the Liberal Democratic Party of Japan, has been in power in Japan since 1950, with the exception of 4 years, and as the sort of moderate to more extreme right-wing party in Japan. The current Prime Minister of Japan, Shinzo Abe, is a nationalist. He is the grandson of a guy called Nobusuke Kishi, who was a Class A war criminal, but was never tried, and was a post-war Prime Minister of Japan. Yeah? You know how there's always, so if, you know, when a Japanese Prime Minister goes to the Yasukuni shrine, there's always this big reaction, you know. One wonderful thing about that shrine, if you go to that shrine, you will see before the entrance there's a big memorial stele in the honor of Judge Pal, the dissenting judge of the Tokyo Tribunal. He has a memorial plaque. When Shinzo Abe visited India 10 years ago and spoke before the Indian Parliament, he praised the noble spirit of courage of Judge Pal. So whereas in Germany, the denial of German crimes in World War II is today a very fringe thing. It's not mainstream. In Japan, the denial of Japanese war crimes, today, 70 years after the fact, is perfectly mainstream. You have whole organizations devoted to that, and the people who run the country are actually affiliated with that, and they use nationalism in order to profit from it. And so on and so on. If you talk about Rwanda, in Rwanda they don't hate the ICTR the way the ICTY is hated in the former Yugoslavia. But why? Because the elites in Rwanda never felt threatened by the ICTR to the extent they had to demonize the tribunal. There was one attempt by the ICTR for a Tutsi to be prosecuted. What did Kagame, who by the way runs one of the most repressive regimes on the planet, what did he do? He managed to engineer the removal of Carla Del Ponte as the ICTR prosecutor and the referral of that one case to Rwanda where it was essentially given a sham trial. Yeah? So in all of these cases, what really matters is how the elites react. It is not outreach, you know? So people say in Sierra Leone, you know, you had this wonderful outreach program. Sure. Could you have had an outreach program if the government didn't allow you to visit schools or to use the media or to use the press? Yeah. So my basic point to you is this. Don't expect that simply because an international tribunal, whether that's a criminal court or the European Court of Human Rights, don't expect that because they render a judgment that says these were the facts, that this will persuade anyone who is predisposed to believe otherwise. If the European Court of Human Rights says it was the Russians who shot down the Malaysian aircraft, do you think Russian public opinion on that matter will change? Right? If the European Court of Human Rights says no, it was pro-Ukrainian forces that shot down the airliner, do you think Ukrainian public opinion will change? What will change is the reaction of the elites in these societies, but nothing else. Thank you.
All right, well, I think the collective sense of the three presentations is to induce some sense of modesty on what we can expect or should expect from international law in general and international tribunals in particular. Somehow the very long stretch of time we once seemed to have for discussion seems to have evaporated. But nonetheless, we do have some time, and perhaps we can take up some of the time scheduled for coffee. So I suggest to give the floor to you. If you have any question or comment, please introduce yourself and indicate to whom you would like to address your question and comment. And I will try, if at all possible, to cluster the questions and comments together. Yes, please. You have a mic?
I can speak loudly.
Please keep it brief.
Yeah. So, no, it doesn't work in any case. Alessandra Lavacara from the Graduate Institute. I have two questions. One is for Marco and one is for Sarah. For Marco, how do you see the post-ICTY strategy based on your comments, in particular the establishment of information centers in the context affected that would be probably implemented in the near future, and is going to be implemented right now, at least in Sarajevo? And for Sarah, you have used the definition of the Secretary General for the Transitional Justice, and in that very same report, there are two other definitions. One is for the rule of law, and another one is for justice. So I'm wondering what's the place of these two other pillars of the post-conflict dimension, and how these two other pillars play a role in your findings or in your questions that you address to Ukrainian audience. Thank you.
All right. Hold on. Are there any other questions that relate to these topics that have been put on the table? Then, okay. No, then I do suggest we take them by theme so we can move on to different topics. Can Marco, Sarah, can you briefly address this question?
Thank you, Alessandra. I don't think it'll matter at all. You can have as many information centers you have, but nobody's going to go there, right? I mean, no Serb is going to go to the Sarajevo Bay Center and learn the truth about Serb committed crimes. It's just not going to happen.
I think in theory, are we holding? Yeah. In theory, these things, and especially in the Secretary General's report, these things go in hand very nicely. Of course, we can understand why. You know, transitional justice aims to promote justice, and transitional justice, of course, is also supposed to be to support at least one element of it, the rule of law, to show that law is stronger than violence. At the same time, what we see in practice sometimes is that the pursuit of transitional justice may be in tension with the rule of law. For instance, what we've seen in Uganda is that there was such pressure from civil society, particularly international civil society, to undermine or to end the Amnesty Act, that the Amnesty Act was reinterpreted in such a way that amnesties already issued to thousands of people were effectively annulled, which of course undermines legal certainty if you can no longer rely on the value of a law that was passed. So I think in theory all these concepts go together. In practice there may be tensions.
All right, second question over here.
I have Valentina Polunina, Heidelberg University and Munich University. I have a short comment to Mark. I conducted a small survey on the acceptance of international criminal justice in Ukraine, and we were talking about ICC and among different actors, for example, legal experts or human rights lawyers who understand all these challenges that are associated with possible ICC's involvement into Ukrainian situation. You talked about, they still accept it and they still have high hopes into ICC's involvement, and not only, so to say, experts, but also other kinds of actors who are not legal experts, due to the fact that there is little trust to national authorities. So it's the kind of main reason why they still accept ICC and still accept ICJ, despite the fact that there are some challenges associated with their involvement. Thank you.
Any questions, comments related to this point?
Thanks. I don't really, it was just a comment, but thank you for the comment, and that's very interesting. And I guess I would just say, you know, I think that's, the criminality is fine, right? Did you see ICC as a plug for criminality? It's just not a replacement, or might not be conducive to conflict resolution. That's, I'm trying to parse those two things out.
Yes, please. For second row.
Thank you. My name is Katerina Buso. I'm a Ukrainian international lawyer, and I've got two questions to Mr. Marko Milanovic. You commented on the public perception of the ICTY, but could you also comment on the post-Yugoslavian, former Yugoslavian public perception of foreign judges and prosecutors who were embedded locally, say in Bosnia? So did the fact that they were locally embedded make them more positively perceived? And the second question is that, do you think that if the ICTY procedures had been better communicated through the media or by the local lawyers within the former Yugoslavia, the perception would have been better? Because it's really crucial for Ukraine, as the second speaker noted. We've got a slightly one-dimensional view of the possible ICC prosecutions here. Thank you.
Yeah. So on your first point, this is actually a point that has been raised in a lot of theoretical literature of transitional justice, whatever, the distance, somehow, because it's in The Hague, that's why it's not trusted. If it was in Belgrade or Sarajevo, wherever, then it would be trusted. That makes no difference. So you have the State Court of Bosnia and Herzegovina, which, as you said, has foreign judges, and which actually is trying an enormous amount of people, more people than the ICTY. And for example, the Bosnian Serbs hate that court as much as they hate the ICTY. You know, you had the Bosnian Serb president threatening a referendum on abolishing it and so on. Yeah, so they really don't like it. So I don't think that matters. What matters is what they say. It doesn't even matter whether the trial is fair. Yeah? If you don't like what the tribunal said, you will always say the trial was not fair, even if the standard of fairness they provide is light years ahead of your domestic legal system. Okay? So that's in the funny thing. If you look at these surveys, the people of the former Yugoslavia know their domestic legal systems suck, right? They know they're corrupt, they're awful, whatever. But they still say, oh, but we would trust trials there. No, you wouldn't, yeah? So that doesn't matter. What was your second point, sorry? So, excellent point. So, 2 points. So you, for example, for an extended period of time, you had the whole trials being broadcast on a national channel. You know, the trial of Milosevic goes on, and for days and days and days and days, all day the trial goes on. It's incredibly boring, right? I mean, unless you were there in a courtroom, you just don't know how boring criminal trials are. They're incredibly boring. Even the most iconic ones. There's a one or two moments that are wonderful, but then you have to drudge through it. And the translation, which you have to have, you know, the interpretation from online, it makes it so much worse, okay? So people stop watching it. The only people who continue watching it are those who are committed one way or another already. So it doesn't change anything. What would have changed things is in the 1990s, what kind of propaganda were you faced with? And that was my problem, but does the regime, does the elite support the work of the tribunal or oppose it, yeah? It would be wonderful if the Serbian state TV was saying, trust the ICTY, but they were saying the exact opposite. See what I mean? And they had no interest, and still do not have an interest, you know, if you look at all the media in Serbia, to say the opposite, yeah? So in theory, what you say is the crucial thing, but it all depends on who controls these media and what will they allow to be said there.
There was a question in the back row, I believe, yes.
Hello. Astrid Reisinger Corosini with the University of Salzburg. I have two questions. One to Mark Kersten. You proposed that the ICC, with a view to a possible Ukrainian situation, that the ICC will never be able to solve the root causes of the conflict. And of course, I agree with you. But on the other side, if you claim something like that, would you not, talk about the pre-existing expectation that the ICC would ever be possible to solve root causes of a conflict? And I don't think the ICC could be able to do that, and not only in terms of jurisdiction, but only, and this is going back to Sarah's presentation, because it's just not a legal reason, it's socio-economic reasons that lead to conflicts, and probably a legal court is not the apt forum to deal with such issues. And then I would also like to weigh in in the discussion that is already going on with regard to Marco's presentation. I mean, you mentioned distance as a factor, and I wanted to challenge this, but then in the end you did it yourself, because you said that actually distance is not really of relevance. What is of relevance is the trust in the institution, and then what the elites, the credibility and what elites are saying. But where does this lead us? And I'm not sure which one of you talked about victor's justice before, but does it mean that only victor's justice in the end will be successful in international criminal justice? And I'm afraid of the answer.
Okay, so the first part of the question raises the very important point of what one can reasonably expect from criminal tribunals. And perhaps there's somewhat of a straw man element in critiquing criminal tribunals for not addressing root causes, because obviously they cannot be expected. Can I ask both Mark and Sarah to briefly address that question? Okay.
Thanks very much. I mean, I agree completely, but the question is, where do those expectations come from? And my problem, or my critique, would be actually that those expectations come from the community that supports the International Criminal Court and from the International Criminal Court itself. It might not always talk about root causes, but it kind of does, and it certainly talks about itself as constantly contributing positively to peace. It actually kind of has a Janus-faced approach to this question of its role with regards to conflict resolution and peace. It says, one, what I think a lot of lawyers say, which is actually peace is the prerogative of other institutions. It's political. It's not our job. We're just a criminal court. And then it says there's no peace without justice, and when we intervene, we only have positive effects on peace. That's not fair, I don't think, to people who are attempting to resolve conflicts. And I don't think I don't think it's accurate. But I think it raises the expectations. So I'd be willing to stop the straw man or the perceived straw man argument with regards to judging the ICC for its effects on conflict resolution and peace if the ICC and the Office of the Prosecutor in particular agrees to stop talking about its positive effects on peace and how necessary it is for conflict resolution.
I fully agree with Mark's point, and I would make one addition, which is that it seems increasingly, even in prosecutorial statements of the ICC and some other courts, is that they say, well, actually, we should do more about root causes. We are frustrated that genocide, crimes against humanity, war crimes as such, we focus too much on physical violence, and we should, for instance, look at land grabbing, or we should look at economic exploitation of particular areas. And we should start going into this, because in that way we make a better contribution to addressing root causes. Now, my question there is the best way towards conflict resolution the lens of criminal law? I mean, can we address issues that are of such complex causality should we address that through prisons and the preceding trial, or are there other mechanisms better addressed to that?
Yeah, hold on, there's still a second part of the question. Is anyone who wishes to weigh in on this particular point of expectations, potential? Then Marco for the second part of the question. You still know what it is.
Victor's justice.
Yeah.
So I think isn't all international criminal justice victor's justice, more or less? Won't it always be that the powerful will judge the weak, right? Has it ever been otherwise? Has a strong person ever been judged while they're strong at the time they're being judged? Nobody, right? You cannot be a head of state and you're on trial unless you actually are willing to do it, like Kenyatta and Ruto did, right? Or are out of power. So in some way, all international criminal justice has that dynamic. Will it be successful depends on whether it aligns with, it's successful in the sense that it is believed or trusted, whether it aligns with what people who run a particular society want. And Mark, you were saying the ICC should always be even-handed, whatever. That's not necessarily, if you want the ICC to be trusted, that's not necessarily true. Because in Kenya, what happened? The two opposing sides, they joined forces. The moment they joined forces again, because the ICC charged both sides, and the moment Kenyatta and Ruto joined forces, they demonized the ICC to such an extent, there's nothing you can do with it in Kenya anymore, right? So, I take your fairness point, yeah? But I'm not sure it directly relates to the trust point.
We had a question here. Yes.
Thank you very much. Ilya Nuzov, I'm an international lawyer from New York. I have a question for the panel. Do you think that transitional justice could or should cause an evolution in how we perceive international criminal responsibility as such? And I'm referring to international criminal responsibility of entities. As you know, in 2015, the appeals panel of the STL had, for the first time, declared a corporation criminally liable. Do you think that perhaps we can see in the future an international criminal tribunal indicting a collective entity, and perhaps this could lead to addressing some of these problems of penetrating sort of the collective responsibility of societies and causing mass violence?
I think it's a great question. If I'm correct, then no, I think the way that international criminal law would work in this instance is that it would never prosecute an entity, but an individual within that entity. And I think the confusion there might be some confusion there of what that would mean, which isn't always useful in the same way that individuals are prosecuted and then the state is seen as responsible, the collective, and there's some tension there between the group and the individual. I don't know if there will be any kind of transitional justice revolution with regards to that, but I do think it's important or notable to highlight that in its policy paper on case selection and prioritization, the ICC mentioned environmental crimes for the first time. I think they did it in a very passive way. They just mentioned it and then it got all this media attention. And I think the Office of the Prosecutor regrets the way that it did it because it caused this great kind of attention, and all of a sudden the ICC will prosecute climate change deniers, which it obviously won't. And the like, but I think it is interested in potentially using that eventually to prosecute, for example, individuals who have worked in corporations, oil corporations that have caused massive oil spills in the Niger Delta, for example. So we would look at that as a potential crime against humanity. So it's possible. I think it'd be difficult, but it's interesting that they're inching. It seems that the trajectory is inching towards that.
All right. Before I get to you, there was a long forgotten question. Maria. Yes.
Yeah, I have a question for Marco. When you were doing your research, was it denial of facts, or was it rather, or in combination, or you saw somewhere the denial of importance or significance of the facts that are kind of not disputed? I'm asking because in Russia these days we have this scary trend of reassessing Stalin's legacy, and it could actually go into your theory, because we had this point of time where Khrushchev actually denounced the actions, right? So in a way, in the society, we don't have the dispute over the facts, yet the attitude is kind of there. And it seems that they seem to refer to some second block of potential arguments, like, yeah, it happened, but kind of there were more important things, or like he made Russia great again, kind of at the time. So, well, in this specific example. So I was just wondering if there is any parallel in your research with regard to other situations that could be helpful.
Okay. You still state your name for the record?
Maria Isaeva, a human rights lawyer from Russia.
Yes.
So short answer is the research mainly dealt with facts rather than the significance attached to those facts. It is, I take your point about the Stalin example, but it is rare for people to be able to say, yes, 10,000 people were killed, but it's not so important. See what I mean? So atrocities rarely get denied in that particular way. What happens is, for example, they say, it was 10,000 people, but they were not civilians. They were people who died in combat. So it is the criminality of it that is being denied. A lot of the research I looked at from the psychological standpoint dealt with, for example, denial of climate change, right? People who believe that homeopathy works. People who believe that vaccines cause autism. Yeah? Those people do not get persuaded otherwise because the United Nations panel on climate change produced yet another study. They do not get persuaded otherwise because there's another study that shows homeopathy doesn't work or that vaccines have no relationship to autism. Yeah? It is because these beliefs are emotionally derived. Yeah? And you dismiss them by constructing a fairly plausible, there's a conspiracy of big pharmaceutical companies kind of theory, right? That is very easy for you to come by while maintaining your sense of identity, et cetera, et cetera, et cetera. So that's the kind of research I looked at.
All right, we move first to this side of the room.
I'm Murat Abedbayev, an international lawyer from Russia. My question is also to Marko Milanovic, the most popular report here. So I'd like to take your research a bit further, at least pose a question. So your contention is that the success of transitional justice depends on how elites react to the justice, and the question is what makes elites react in this way or another. For example, many people believe that the success of denazification in Germany was due to the occupation powers. So would that be the instrumental answer to this question, is that a country needs to be occupied, or there must be a change of elites, and again, how does this change can happen instrumentally?
Okay, this is, I think, actually part of a broader question that Sarah also raised with the question, who is, in a way, in charge of the mechanisms and the toolbox? So I'm going to ask Marko and then Sarah to reflect on this.
Sure.
It's a superb question. Thank you so much. So I think you're right. If the elite once finds it in its interest to react negatively to a tribunal, that will almost always be because there's a continuity between the elite that is reacting today and the elite that was involved in the commission of crimes, etc. So it was the disruption of the German and Japanese elites during the occupation that was the key driver of the social reforms that happened in both states. And it is precisely the difference between the levels of disruption. In Japan, it was much less than it was in Germany. That is directly causally related, I would say, to the acceptance of the relevant tribunal. Yeah? The fact that we as lawyers say Tokyo was inferior to Nuremberg doesn't really matter. What matters is the people who actually responded, the people who shaped the educational system, the people who shaped the media, and so on. In Germany, you know, people talk about denazification, but denazification was only really at the very top. For example, the legal profession in Germany, law professors in particular, were never denazified, and they were the biggest Nazis, okay? And that's why you have, as soon as the occupation withdraws, that's why you have Nuremberg being devastated by these political intellectual elites that ran Germany at the time. However, they were nonetheless forced to realign themselves with the West. They had to become a democracy. There was no profit in perpetuating Nazi ideology and so on. And that's why they chose that silence was the better strategy rather than always talking about it and denying the Holocaust and so on. And that's what led to a space in which change could happen. In the former Yugoslavia, what you have is complete elite continuity. The guy who runs the Bosnian Muslim side of things is the son of the wartime president. The current president of Serbia, the president-elect of Serbia, who, by the way, would not have been that were it not for the ICTY who indicted his former boss, which is a long story. Yeah. He's an ultra-nationalist who was active during the war. Yeah. The vice prime minister is the leader of Milosevic's party. Yeah. In Croatia, the same nationalist party that was run by Tudjman, the wartime president, is in power now. Yeah? So it is that continuity of elites that's the biggest predictor of whether they will react negatively to a tribunal.
I would like to extend Marco's research a bit to transitional justice more generally, because we've been focusing on the question to what extent do courts get accepted. But what about truth commissions? So when does the work of truth commissions get accepted? And I wonder whether your hypothesis applies there too. Now, on the one hand, I would say, of course, it is a factor, but I wonder whether truth commissions could be in a stronger position, for instance, by having a more inclusive process in which participants, at least, have more ability to make their own judgments. And they can be closer, not so much to the events that happened, but they could theoretically be closer to the confrontation potentially between victims and perpetrators if the Truth Commission has a model like the South African one in which that takes place. And especially if the media supports the process, and that goes back to my point about the importance of having transitional justice coming out of a national policy. And that was the strength of South Africa, that the parties came together and said, okay, what kind of system of transitional justice are we going to have? It's not an ad hoc approach. And I'm a bit concerned here, and I still state it publicly so that people can reject that argument, but that it seems more ad hoc in the sense of taking decisions, okay, we go to the International Criminal Court, without having a bigger transitional justice policy. Okay, how is this International Criminal Court going to interact with reparations or going to interact with our domestic need for reconciliation? The second point that I would like to make, also in response to Professor Nolkemper's question about for whom. A lot of the discussion here has rightly focused on this question, fascinating questions. Does the ICTY or do international criminal tribunals make a difference for the society concerned? My only point of caution would be the ICC is not primarily interested in the difference it's going to make in Ukraine. Ukraine is for the ICC also, or primarily perhaps, a situation in which to establish itself. It needs to think about its own institutional survival and its own institutional strength, and therefore the considerations of what impact it's going to have on the situation in Ukraine will not be its primary driver.
All right, I'm looking for some guidance from the organizers. Do we have any more time, or do we need to wrap up? All right. Okay, so we've already transgressed quite a bit into the time scheduled for coffee. So I suggest we wrap up here. I thank the participants very much for the very useful contributions to the Foundation. And I was told that Max is about to make an announcement. It has to be Max then.
Hello, dear colleagues. I have several announcements. So, the first, I'd like to tell you that after coffee break we'll have separation. And the first section will work here, and the second workshop will be one floor downstairs. So just pay attention. Then, next, the coffee break, this coffee break, will be just next to the right from this hall. Like I forgot its name, but you'll see. You'll smell it. Anyway, please a little bit more attention. Few seconds. I know that you're hungry, but please. Those of you who didn't take conference materials, please take now at the conference table. And if you want your money back for your tickets, also follow me. So, thank you for attention.
Не, ну как круто, это ж прямой эфир. Зачем? Название. Не нужно пока.